Greetings, this is Dr. Della Welch again. I'm talking today some more about negligence. We mentioned briefly res ipsa loquitur, which means the thing speaks for itself. If a plane falls out of the sky, someone must have been negligent. And so we use res ipsa loquitur to establish the duty and the breach of duty. Suppose you buy some soup, and the soup says cream of chicken soup. Well, you get it home, and you open up the can, and you see a dead mouse in there. In truth, it is cream of mouse soup. Well, a mouse doesn't enter a can of soup unless someone was negligent. So the thing speaks for itself, and the instrumentality must be in the complete control of the soup maker, and someone didn't tamper with the soup at the store. So res ipsa loquitur is a very good theory of establishing the duty and breach of duty. Now there are other duty rules. Handicapped people, such as those who are blind or hard of hearing, they're held to the same standard as a reasonable blind person or a reasonable deaf person. However, if there is a mental illness, there isn't that same discount that there might be on someone with disabilities. For example, there's a famous case of a handicapped person who was mentally handicapped, and he was driving a tractor, and he ran into various people. Well, it was found that he was liable in tort for hitting those people, regardless of the fact that he was mentally challenged. Now there's the rescuer's rule, and rescue it contains a risk, and it invites risk. And so if someone injures another and causes an ambulance to have to come, and the ambulance driver is injured, well, the defendant is responsible not only for the injuries to the person, but also for the injuries to the rescuer. Now, some states have Good Samaritan rules, and doctors, if they assist others on a plane, they're not liable for negligence. You would have to check your own individual state rule about the Good Samaritan rule. The general rule is you do not need to come to the aid of another. Suppose it's a stranger and you have no special relationship. But, however, if you do come to their aid, you can't put them in a worse position. Let's say, for example, I'm teaching a class, and I go out of class, and I see that one of you is out of gas. Well, I go to help you. I say, get in, and we'll go to the gas station. I'll help you get gas. But suppose instead I drive you up to the canyon in a remote area. Well, I have put you in a worse position, and then I would be liable if you're injured there and so forth. There's also rules of violation of statute. Suppose a city has a rule that fireworks are not permitted, and the intent of the rule is that they do not want fires to occur in the city during the firework season. I use a mnemonic ICI whenever there is a statute in question. Is it the intent, that's the I, of this particular statute to protect this class, that's the C, of persons from this type of injury? That is the I. So you have I, C, I. Well, suppose that a young child, about 3 years old, goes to the fireworks stand with her parent, and instead of she buying the fireworks, the child eats the fireworks and gets very sick. Well, was it the intent of the statute to protect someone from eating fireworks? No, that wouldn't be the type of injury protected. So then we have land owner-occupier rules. A trespasser is someone who just comes on your land, and you have a low type of duty to that person. But if it is a child trespasser, and you know childs are about to frequent a particular area, you may have an attractive nuisance. You may build a little water well on your property, and children, because of their age, would not be able to appreciate the injury. So in that case, if the child comes over and gets injured, you are liable to a child trespasser. So this will be the end of this tape. These tapes are not intended to give legal advice, but to help you understand the law. This will be the end of the tape.